So hello everybody, welcome back to Law Hero. My name is Jen and tonight we are doing contract law and we're going to talk about breach of contract. Taking a step back from law at all, like people always get so caught up with defining terms and understanding the law, but I think the best thing to do is put yourself in a real life scenario. And everybody knows I love chicken nuggets, I love McDonald's, I call my dog a chicken nugget even though he's not a chicken nugget. And that's just the best idea that comes into my head right now. Okay, so you go to McDonald's and it says 6 chicken nuggets, okay, and you come out with 4. That is a breach of contract because it was represented to you via the menu, via the advertising, and also it's written on the box. So I mean, you've got a lot of evidence right there that you were supposed to get 6 chicken nuggets, but you accidentally, or maybe it wasn't accidentally, maybe it was on purpose, maybe they don't like you. It doesn't matter about the intention because it's strict liability. They have breached the contract. They made an offer of 6 chicken nuggets. You accepted that offer. You paid the price which they offered. The price they set for the offer, you paid the price, you exchanged legal tender, which was money, and you got the goods, which fell short. You also have which fell short of the description. So where is the contract? The contract is just as I described, and because this contract is a consumer contracting with a business, we also have consumer legislation. So it is the Sale of Goods and Supply Services Act 1980. And what area under that act would you use is not as described. For example, you could use that one. You could also say it's not fit for purpose because you needed 6 to fill yourself and you only got 4, although that one's a bit of a funnier argument. Yeah, I think you definitely would say it does not correspond to the description. Okay, so we'll go on that. So we have a remedy in statute. We also have a common law, an agreement, but because we have statute, we kind of forget that we have a common law agreement. I'm trying to think, is there anything else? No. So we will go to statute. Now the question is, what happens if I am 2 businesses and I can't rely on consumer legislation like I did with the chicken nuggets? So what if I am X Limited and I sell bottles of water to Y Limited? And in the same vein, I ordered 100 and I only got 15. Just a wild example. Now, where is my remedy in law? So the first place we obviously go is the agreement between the parties, which is the contract. And in there it says, I was supposed to get 100 bottles of water on Monday. I only got 15 now. What is my remedy? So the very first thing is that, has there been a failure to do something agreed? Yes. Okay. So performance has been hindered under the contract. Is there, the next question you ask yourself, is there a legal excuse for this performance not being reached? So when you think of legal excuses, you think of, for example, frustration, impossibility, force majeure. We assume here that none of those things have happened. We assume this is straight up, they just didn't give us the bottles we need. Okay, so the very first thing we have to do is prove the breach of contract, okay? Because otherwise, there's no point in trying to take an action against the other party. Okay, so the first thing we need to prove is that there is a legally enforceable contract between us, the plaintiff, and the defendant, the other party. And as I just said, we had an agreement, so yes, we have that. The second thing we have to prove is a failure by the defendant to adhere to the requirements and terms and conditions of the contract. So we have in our services scheduled in our contract, we were supposed to get this many bottles on this day, and that did not happen. So we're okay there as well. And thirdly, we have to prove that we suffered a loss because of the non-adherence. And we can prove we suffered a loss because we paid for 100 and we only got 15. Therefore, 15 from 100 is 85. That means we have suffered 85 of a loss. And remember as well, breach can occur through an act or omission, so by doing something or by not doing something. Now, the other thing we have to ask ourselves is there a materiality threshold in the contract, right? Because sometimes in contracts, it will state that in order for a breach to actually be a breach, there needs to be a material breach. And sometimes the material breach will say something like, for a breach to be material, it needs to be there needs to be a 50% loss in what was to be delivered under the services. So here, as I said, we have 85% loss, so that obviously reaches the threshold. It depends how materiality is defined in your contract, but you have to be very careful around that. Okay, so let's say, for example, that the party have said that they are the only ones in the country who can deliver these bottles, okay? And that these bottles are engraved in this beautiful gold lettering for a wedding, and if the bottles don't come on the wedding day, nobody's going to get their little present going home, and it's going to be an absolute shambles. Basically, that damages would not be an adequate remedy given the circumstances, as in they had promised everyone a bottle. I'm making up the circumstances here. They promised everyone who was coming to the wedding that they would get a gold engraved bottle, and people signed an agreement saying that they wouldn't come to the wedding if they didn't get their bottle, something like that. And basically that money's not going to help here. They need their damn bottles. So what I'm obviously alluding to is specific performance. When damages are not an adequate remedy, so damages under contract law are not an adequate remedy, you need to go to equity. You need specific performance of the services that are owed. But as we all know, specific performance is a really dicey defense, is a really dicey remedy, because the courts are loath to give it because they don't like enforcing services contracts that are based on monitoring performance. So for example, this is usually in the context of employees. It basically means that you can't force somebody to do something, and it is at the discretion of the court. Because it's an equitable remedy, it's a discretionary remedy. An order will not be granted where damages are an adequate remedy. So arguably at my wedding, I probably could have got the money and bought some other bottles, but I only wanted those bottles, to be honest with you. Contracts that require ongoing supervision, how do I know they're not going to write something awful on the bottles? And open contracts, as in ones which are not, where the services to be rendered are not specifically described. So yeah, basically your chances of getting specific performance are few and far between, even in the context of employee-employer. Right, moving on to termination. So obviously you will have termination for cause, usually for insolvency, for breach, there might be other triggers like change of control. And then there will be termination for convenience, which means basically after giving a certain amount of notice, either party can walk away. A right to terminate for breach arises in 3 circumstances, and this is really, really important for the FE1 because it comes up all the time. So the first one is fundamental breach, and that is a breach so serious it terminates the rights and obligations of the innocent party. That means it's a breach so serious that the performance of the defendant doesn't need to be, for example, paid for. Like that it discharges your obligation to pay them. And that would be, for example, gross negligence. Like it's hard it's hard to describe the difference between fundamental and repudiatory breach, but what my understanding is that like a repudiatory breach is extremely serious and ceases the contract immediately, as in from that point on the contract is terminated. So if I have if I want to get out of my contractual obligations, I will try and use some defenses. The very first one most people claim, especially when it comes to mortgages or some kind of guarantees, when it comes to family members, is duress or undue influence. It's a very good one to plead. And you might remember from Barry v. Ennis Property, there has been some update as to what questions there should be asked to see if there was undue influence has taken place, including the commercial experience of the claimant, the relationship between them, and the nature of events which led to this influence being alleged. So it's becoming a little bit tighter the more it's pleaded, which is a good thing, obviously. The other one is independent legal advice. So this came out of banks not giving the guarantor or the other party, especially when it came to family property, a chance to gain independent legal advice, that they didn't understand the nature of what they were signing. The third one is public policy and illegality. So basically you claim that the contract is contrary to public policy and unenforceable. This was actually pleaded in the IBRC and the Quinn family proceedings, where they argued that they should not be liable for the guarantees on the loans because of the regulatory and statutory breaches on the part of the IBRC. The court noted in certain cases a finding of illegality may result in an unjust windfall for one party, and considered whether or not the public policy aspect of an illegal activity should automatically render a contract unenforceable. And in that case, they held them to be enforceable notwithstanding the illegality. So you can plead illegality, but the court will look at the circumstances around that. Force majeure has been used a lot during COVID, and now you will see a pandemic being listed under force majeure clause. Frustration is also a supervening event which occurs outside your control. If you remember Krell v. Henry, and they're called the coronation cases, you'll remember them from your FE1. And it only takes place after the contract has been entered into, and it discharges an otherwise valid contract. And just remember, in that case, the deposit had been paid on the room, and the room was still being capable of being used. So there was no frustration around using the room. The frustration was around the event of not being able to see the Queen being coronated. Just remember that. So yeah, that is breach of contract. I feel certainly more learned having gone through that. I hope you enjoyed it, and I hope you feel more confident when you sit your next contract law exam or when you do those pesky negotiations. I wish you the best of luck and keep those agreements nice and tight. Make sure you have your materiality. Make sure you set out your breach properly, and make sure you always have termination for cause and convenience, just in case you get into any sticky situations with your counterparty. I'll see you in the next one.